111690, State of Kansas v. Jerome Brown.
May it please the court, Kristen Patty on behalf of the appellant, Jerome Brown. Your Honor, may I reserve 3 minutes for rebuttal?
3 minutes is granted.
I know I'm supposed to give a short summary of the facts. In this case, you all are well familiar with the facts. A year ago this week, you heard oral argument on my client's co-defendant and brother, Sean Brown. And I think the opinion Justice Stigall wrote was finally issued in September. For the audience, probably the facts that are most important, at least in my mind here, are there were two separate first-degree murder incidents. And in this appeal, we're really only focusing on one. 5 years ago, Adji Tampone, and I'm sorry if I am mispronouncing his name, did not keep his plans with friends for New Year's Eve. During the next few days, his friends tried to contact him repeatedly, drove by his house, didn't see his car. And then finally one of them decided to breach the back fence, I think it was, and they saw Mr. Tampone kind of slumped in a chair through a window, and then that's when they called police. I don't know if any of you watched the KU game on Sunday. At one point after an Arizona State basket, the Jayhawk catches the ball as it comes through, and he steps out of bounds with 1 foot, but doesn't take the other foot out of bounds as well before inbounding the ball to his teammate. And of course, what happened? That's a turnover. The referee blows his whistle, and KU loses possession. I wasn't here yesterday, but I understand that basically happened yesterday too. A counsel for an appellant forgot to ask for his rebuttal time, and when he went back up here to the podium for his rebuttal, he was turned away. Here the problem is that the state, when it was conducting its cross-examination of the coroner regarding Mr. Tampone's autopsy, forgot to introduce the autopsy photos into evidence. No one caught it. They went back to the jury room with the other admitted exhibits. And for that reason, we're asking that you reverse his conviction, at least on that first-degree murder count, probably really in some ways, I think all the counts related to that homicide, and remand his case for a new trial.
Why isn't this a preservation problem? Because if you're talking about something that hasn't been admitted into evidence, that's why there are defense lawyers who stand up and object, or state lawyers for this, if the other side's doing it. I don't see how you get around the contemporaneous objection rule.
Well, first of all, the contemporaneous objection rule states that it applies to evidence that was admitted. And if the state doesn't jump through the hoops that we all learned in trial ad about how you introduce evidence, particularly documentary evidence in this case, into court, then, I think the only case this was a hard case to brief because there isn't nationally, it doesn't seem to be any published opinions on something so basic. I've got an Ohio case, I think it is, that says you have to object at the time that it's offered and admitted. So if it's not offered and admitted, do you really lose your right to object to it? The other problem is, and And because
Was
this,
there any ever objection to the photographs? Typically, not only at the time when they were discussed and marked, identified, all of that procedure happened. Typically, before, usually at jury trial conference or jury instruction conference, excuse me, there's kind of a discussion. Okay, this evidence has been marked, it's been admitted, it's going back to the jury room. Typically, all the exhibits, all of the photographs, all the reports are gone over with counsel during that part of the trial procedure. Did that happen here?
yes, kind of. There was one point, there were two prosecutors on this case, and there was one point where the other prosecutor, who was the more experienced of the two, and with the judge outside the presence of the jury, does discuss. They just have a brief, few lines about what their respective lists show,
And defense counsel and defendant are a part of that process.
They are in the room. You're correct.
They're in the room, and there's a discussion. And typically, it's on the record. I don't know if it was in this case, but almost always it is, particularly in a trial of such great importance. And so that process occurred, I'm assuming.
It did, and that created a little bit of a problem for me, because you've got a court reporter's note in that part of the transcript a couple of days later that says these autopsy photos were admitted. But the problem is there's not the colloquy between the prosecutor, the defense attorney, and the court regarding that we usually see with the admission of the exhibits.
But how do we know that didn't occur off the record or some other way, and the court reporter was just summarizing what occurred there, memorializing it in essence? A court reporter wouldn't normally just add that to the record without there having been some process occurring.
I would certainly hope not.
So why do we not just take that statement that's in the record at face value and that documents that they were admitted?
Because there doesn't seem to be like there was a recess surrounding that point. It's kind of interjected into the discussion that the lead prosecutor and the judge were having about the exhibits generally.
What ability do we have on appeal to question the accuracy of the record? And that is part of the record.
I think I had to use an Idaho case and a Missouri case, and those are really hard to find. It's difficult to convince you, at least, that there's a lot of other authority out there. It's the importance of the colloquy, and something as important for this, even if they had that, then they needed to make sure that it was on the record, and it wasn't.
It appears from the record that these photographs were published to the jury contemporaneously with the physician's testimony.
Yes.
Why is that not admission, de facto admission? Isn't that the point where the defense counsel should have been on his or her feet, I'm not sure, saying, Judge, until there's formal admission, these cannot be published to the jury?
If she had done that, certainly I wouldn't have had that issue. And, both Mr. Gillette and I had problems getting the record together in this case, because the exhibits, the actual pieces of paper used in this case, were used in another case and ended up in that record on appeal. So certainly if she had done so, I wouldn't have this issue.
Well, let's look at
That
it from a
seems to-
different standpoint. If the Dr. Gorell identified, explained, and discussed each of the exhibits, 22A through 22H, and there was discussion about putting them up in the corner on the Elmo projector, and so they're up on the projector, the jury's looking at them, the coroner's explaining them, and uses them for the purpose that we allow to explain the injuries and cause of death. And at that point, what is the prejudice to the defendant if the words "I move to introduce" granted? I mean, what difference does it make, because the damning effect of the photographs has already been put before the jury, and that additional step would not have caused any more problems for the defendant?
I understand that. And I guess because I still have Justice Lukert's question also kind of hanging out here. I suppose that, yes, it would have been nice if the trial attorney had objected. I suppose the problem is we already place a considerable burden on defense counsel to object and to object contemporaneously. And we do require technical compliance with the rules in other situations. For example, when there's been an evidentiary hearing on a motion to suppress and the defendant has lost that, and we all know that they're contesting that particular piece of evidence, you still say you've got to object when the evidence comes in at trial, right?
And that hurts you here, doesn't it? Because, I mean, there was just not a peep at any point when they were effectively treated as admitted.
I know. I would caution the court to place upon defense counsel an affirmative duty in this type of a situation to speak up. Her job in that courtroom was to be a zealous advocate for her client. I think I kind of meant to say this earlier and I didn't. You know, actually, when I had to talk with her about these exhibits and get replacements for them, she hadn't realized. But her job is to represent her client. We wouldn't expect her to go over to the state and say, oh, by the way, you forgot to prove this. Or we wouldn't expect the state to say, when evidence from that motion to suppress comes in, defense counsel, aren't you going to object to it? That's not the way that it works.
But every objection, excuse me.
Go ahead.
But every objection by defense counsel puts the state on notice that it may be headed for error, headed for appellate reversal. So if you extend your argument to its logical conclusion, then the whole thing becomes a big game of sandbagging the other attorney, doesn't it?
Well,
I mean, no matter what, whether it's the state objecting to something defense counsel is doing or defense counsel objecting to the state, what you're doing when you object is saying, whoa,
sure.
Danger, Will Robinson, error. And you're putting your opponent on notice that something's getting screwed up that could end up in a reversal on appeal. That's true in civil, that's true in criminal, every kind of case. So we can't really condone a defense counsel sitting on his or her hands and keeping their lips zipped when error is occurring.
That's true.
And just because it's going to advantage the client on appeal.
The problem is you also said, or at least this court said back in 1952, we can't condone an unadmitted exhibit going back to the jury room. And that was a different situation, and there were other grounds for reversal.
Generally,
in
I
that
understand
case.
that. But once it's been effectively treated by everybody in the courtroom as an admitted exhibit, I don't understand why we should say that was error. But even if we say it was error, I can't understand at all, and this relates to my colleague to my last question, how can it ever be prejudicial?
Well, the problem is she wasn't the only one. There was the lead prosecutor who, the minute she started to publish to Elmo, also could have said, Your Honor, may I confer with co-counsel for a moment? Or the judge has a responsibility to be ever watchful. When she started to publish to the Elmo, he could have said, may I see counsel at the bench, please? No one else did it. And yet we're putting all the responsibility on defense counsel here, and I don't think that it was her responsibility, like with a motion to suppress, for example, to object to that testimony. There were also other places, other ways that the state could have cured it. You've said that I think this was from the 70s, you don't disfavor en masse admission of exhibits, but they could have done that. And we were talking about that court reporter's note, if there were en masse, by the way, just we want to make sure we admitted all of our exhibits or something. There was also, I found one case where it said maybe if they'd realized it before verdict, they could have come in and that would have been within the court's power as far as its control of the offer of proof.
But the question was, what difference does it make? Why is it prejudicial?
It's prejudicial because there was no opportunity for an objection. I don't know whether there would have been. Certainly, yes, I hope she would have spoken up if there would have been an objection. And it's also because we require sometimes technical compliance with the rules, even when we all know, and like I've used the motion to suppress example, even though we all know that that's what the attorney was wanting to do.
The objection here would have maybe not been to the admission of the evidence, which is the point that you continue to make. But there was an opportunity to object to the use of unadmitted evidence by publishing to the jury. And why doesn't the contemporaneous objection rule apply to any evidentiary error that is, in effect, allowing admission of evidence to the jury, even when the rules have not technically been followed?
Well, I believe that the statute
And
says.
I know you're focusing on that admitted language.
It's not admitted though. It's
Yeah.
admission.
So it's
of.
not
Erroneous
admitted.
admission
It's
of. I
admission,
just wanna check.
and isn't that, and again to the point of, wasn't this effectively admitted to the jury, admitted in the jury saw it?
Before I heard about the attorney for the appellant forgetting to ask his rebuttal time yesterday, the other story that I was going to use is years ago when I was with a firm in Kansas City, an associate lost a trial. And it might have only been a bench trial, but lost a trial on a contract. And so he filed a motion to reconsider. And you know what the judge's answer was? You forgot to admit the contract into evidence. I would assume that there would have been other testimony about contract issues regarding in that trial. Did I assume that the attorney on the other side, if there was one, didn't object either? But that associate lost that case simply because he forgot the technical step of admitting the contract
So
into
are you
evidence.
saying that the failure to formalize the introduction and admission of an exhibit is a structural error in a jury trial?
It can be.
Under what circumstances is?
The only guidance that this court's really given is Palmer from 52. And like I said, there were other reasons for reversal in that and retrial in that case. But it was said, you said that it was something that could not be condoned. There are a couple of Ninth Circuit cases that say that you have to determine that the unadmitted evidence was not prejudicial to the defendant beyond a reasonable doubt. And I don't know that we can really say that here. Most of the evidence in this case regarding this homicide dealt with my client's co-defendant and brother, Sean. He was the one that had Mr. Tampone's cell phone. He was the one that was driving Mr. Tampone's car. Jerome was implicated because he was seen with Sean on New Year's Eve when this is all believed to have happened. And then the other poem, I'm sure Mr. Gillette will remind you, is he supposedly said something in jail, including a description of how Mr. Tampone was lying in the chair, which is, he's kind of got what, his arms, his back is completely down on the seat, and he's kind of got his arms through the sides. Something admittedly that no one would know or should know unless maybe they were there. But without that jailhouse informant information, I don't know that you could conclude that the evidence against Jerome was overwhelming enough that these autopsy photos were not prejudicial. I know I've run completely over my time, my at least initial 12 minutes.
What was the effect of the court stating that there was a conversation about whether the state was done, and the prosecutor says, I'll compare with you the exhibits, but I do think we're going to rest after this witness. The court says, the notes I have exhibits 1 through 33, except for exhibit 28, and that would have included the exhibits 22A through H that you're talking about.
Right.
And the state says, Judge, I believe that's what we have as well. I'll confirm that on the break. I think that's where we're at. Upon cross and redirect, we'll be resting.
And isn't
so
that
they're
where
all
the
talking there about what has been admitted for the exhibits. The defense counsel is there, and there's no judge, that's not correct. I mean, there's no objection that recitation of what has been admitted was erroneous. So why can't we take the district judge at its word that it had admitted those exhibits 1 through 33, except for 28, into evidence?
Well, and first, I think that's the exact point that I was referring to earlier, where there's that court reporter's note. Oh, I guess those exhibits were admitted after all. And that's because there wasn't the colloquy in front of the jury. And if it doesn't happen in front of the jury, does it really happen? I mean, even if there'd been some sort of a stipulation regarding the admission of the exhibits, we would see that in the court file.
So every trial where we have counsel get together with the court beforehand and say we can agree we're gonna admit these exhibits without objection, that actually is reversible error because they haven't done that in front of the jury?
It could be. It depends on maybe how they memorialize it. And the other problem is, I know I've used this example a couple of times. It's the same in my mind as the defense losing a motion to suppress. Even though we know that the defendant is going to want to renew his objection, he's still required to do it.
But the disconnect here is there's nothing in the record anywhere ever that indicates defense had a problem with exhibits 22A through H. Nothing. No one knows whether defense had a problem with it because there was never an objection. There wasn't a motion in limine. There wasn't a motion to suppress. There was never any objection or hint that defense had a problem with it. Which is different than your scenario on a motion to suppress and
Right.
continuing your objection.
And I understand that. And one of the first things that I do when I sit down with a jury trial transcript is I try to go through and at least see whether there are any objections to exhibits, because I want to make sure that I get the process started as far as adding those to the record as quickly as possible. I don't know that it's always necessary to just add them wholesale. I know some attorneys do. And certainly, yes, I will go through jury trial transcripts, and every time I find, an exhibit, there's no objection to its admission. But there's still the colloquy. There's still the taking the both feet out of bounds. They're still asking the Chief Justice for the rebuttal time. They're still admitting the contract actually into evidence despite all the other testimony about it. We require technical compliance with the rules sometimes. And, like the poor KU kid, hopefully he's probably not, that's not the first time he's ever done that. I mean, he will certainly, he's done it correctly a bazillion times before, and it will be a very long time before he ever does that again. But sometimes there are technical compliance and we require.
But you don't lose the game. KU didn't lose the game because of that.
No, they didn't lose the game.
But my point is, yeah, it results in some a turnover, but it doesn't.
Right.
You don't lose. Afterwards, you say, "Oh, you did that. You lose."
KU didn't
And that's what
lose.
you're asking for.
KU didn't. Well, they don't lose. The state doesn't lose because.
Aren't you asking for a reversal?
Well,
I mean, that's what you're asking for.
I suppose as an attorney, appellate attorney for the defendant here, I would always request reversal and acquittal. But I don't know that that's appropriate here. The Ninth Circuit cases.
Then what are you asking for?
A new trial. A new trial. You know,
Get a
the
reversal first.
yeah, the fellow associate who forgot to enter the
So-
contract, certainly he didn't get another chance to do
So
that.
this is akin to reviewing the game tape of the KU game and seeing a call that the ref missed and then saying, we ought to replay the game. Or
Golf. Have you heard that they've decided that they're not going to allow people to phone in rules violations anymore? It's a little bit like that, but that's what appeals
That's
are.
Justice Stiegel to my point. You're asking to redo. Anyway.
Just so I'm, sorry, were you done? Just so I'm clear, the court reporter says the notes were identified and entered into evidence.
Right,
The judge thought he had admitted them.
right.
The prosecutor thought he had admitted them.
Two prosecutors.
They were published to the jury. Defense counsel never spoke up on any time during trial to say, no, they were not admitted,
Right,
correct? In the motion for judgment of acquittal, defense counsel did not raise this issue, correct?
correct,
In the motion for new trial, defense counsel did not raise this as an issue, correct?
correct.
So can we conclude that the principal players at the trial all acted like this evidence had in fact been admitted? They believed it had been admitted, and it had. And your position is that does not matter? Is that what you're telling us?
That does not matter if there wasn't the colloquy. And I always feel silly when I have to pull out my 30-year-old copy of Maouet off my bookshelf when that seems to be the only authority that I can find. I did find it's a Eastern District of Pennsylvania federal case that deals with the same sort of issue. And that was a civil medical malpractice or something like that. And the paragraph right afterwards says something about, sometimes an inexperienced attorney may forget to do this and lose a case, but we require compliance with that.
All right, any further questions? Thank you, counsel.
Okay, thank you.
May it please the court. Again, my name is Lance Gillette, Assistant District Attorney on behalf of the state of Kansas. Briefly, just to hit on the main points in my brief, I'm not going to reiterate the entire thing. Our first point in the brief is that here the defendant failed to designate a record that affirmatively establishes error. As this court and a number of questions have pointed out, The record actually reflects, through the court reporter's note, that these exhibits were in fact admitted into the record. I don't know what more needs to be said about that, especially Justice Nuss, and I think you summed it up pretty well. The judge thought they were admitted. The prosecutor thought they were admitted. The defense appears to have clearly thought they were admitted. In addition to all the facts and highlights that a number of your questions have emphasized, I would also point out that in my brief I note this specific issue was talked about in voir dire as well. And there's an indication from the prosecutor that these autopsy photos had been winnowed down. They had selected those that were necessary in this case. So can I tell you precisely exactly what happened in this case and how these got admitted? I can't, but neither can the defense, and it's their burden to designate a record. And that's particularly fatal when their own authority indicates that the proper remedy and the proper way to raise this issue is at the district court level, through a hearing, through a post-trial hearing, or through having asked for a remand to try to clear some of this up. We believe that the record here indicates that these exhibits were admitted and that there's no basis in reality for defense's argument. Second, regarding the lack of objection, I know a number of you had questions about that, and the state concurs. There is absolutely a preservation problem here. The statute, as Justice Beyer pointed out, deals with the erroneous admission of evidence. And as Justice Lukert noted, when these are published to the jury, that is absolutely de facto admission. That's the opportunity to object. And I've laid out plainly in my brief, there were over a dozen opportunities in this case at which defense counsel could have objected, could have raised this in the post-trial motions, chose not to do so. And I think that's fatal in the instant case. There has to be a timely and specific objection. This is not like a motion to suppress. When we deal with motions to suppress, there can be changes in strategy that occur between the time of the motion hearing and the trial. That's one of the main reasons we require motions to suppress be re-raised, because things can change. Here, a simple objection would have cleared this issue up, and there would be absolutely no issue on appeal. In the instant case. I don't believe that the defense's bases asserted in their brief for raising this issue for the first time in appeal are sufficient either, as I note in my brief. This is not a purely legal issue. There's clearly some factual questioning involved as we don't know exactly what happened between the prosecutor and the defense attorney, aside from the fact that we do know that everyone considered these exhibits admitted. And furthermore, there's this treating this as some kind of a structural error. My first response to that is that's not what was raised in the briefs. There's no basis to do that. And in the defendant's brief, there's a veiled threat to pursue a 1507 petition. Fine, please do. If that's what the defendant wants to do, he should have withdrawn his appeal and attempted to create an appropriate record through a 1507. And we'd litigate it there. But that's not what we've done here. Instead, we're trying to force an issue before this court via inference alone. As to Justice Luke, you had one other question about the ability on appeal to question the accuracy of the record. And I think you're correct that your ability is extremely limited. And I don't think that there is any ability in this case to question the accuracy of the record that is before the court, which again shows that these were admitted. Before I move on to the harmless error analysis, just real quick, opposing counsel from the podium today says it would have been nice if the trial attorney objected, and I would urge this court that it wouldn't have been nice. It was necessary. We have to have timely and specific objections in order to reach these kinds of evidentiary issues. There is no reason for her to not have objected if there was a basis to object. There's no added burden here. The timely and specific objection burden is something that is taught from day one in evidentiary or trial advocacy in law schools. So there's no added burden by simply enforcing KSA 6404, requiring a timely and specific objection. finally, I'll turn to harmless error, and Justice Johnson and Justice Biles, you had a number of questions. They all simply boiled down to the heart of the matter: where's the prejudice? And the state would submit there is none in this case. There's absolutely no way there was any prejudice in this case. I would argue that even under either standard, but we'll use the constitutional standard today just out of ease, because if I can meet that standard, then I've met the statutory standard as well. The evidence in this case was otherwise strong, and I guess what this really comes down to is what more could have been done? Would the prosecutor could they have just simply said at the time, Your Honor, I move to admit, there have been no objection, and then they went ahead and were published? Because there's no obvious reason in the record to support any basis or any reason to think these would have been excluded at all. The proper foundation was laid, and then they were testified to one by one in front of the jury, providing at least 7 opportunities for an objection. There was these photos were relevant and admissible, and as the record will show, the appellate record, I added to the record the crime scene photos, which the state would argue, if anything, those crime scene photos are more prejudicial even than these autopsy photos. And there was no objection to the crime scene photos that showed effectively the same thing. As I note in my brief, there was only one photo in State's Exhibits 22A through H that differed substantively at all from the crime scene photos, and it was one that was of the decedent's brain to simply show injury, to explain injury, and to indicate where the bullet was recovered. Again, there's no reason that this case should be reversed. It was absolutely harmless under the facts of this case. The other evidence, just to note, the defendant's own statements in jail also were extremely important. He admitted to, in fact, bragged about, before anyone else would have had reason to know, how he and his brother had gone to collect drug money and ended up murdering the victim in this case because he didn't have it. They shot him in the back of the head, and they stole his Cadillac and his phone after they went through his house, too. Frankly, there's absolutely no prejudice. I struggle and urge this court to even identify any that's identified by the defense in this case. Simply it's because it doesn't exist. If this court has no other questions, I would yield the remainder of my time and ask that this court uphold the convictions and sentences in this case.
Any more questions? Thank you, counsel.
Thank you, Your Honors.
To address the issue of whether I should have asked for a remand. In Palmer, for example, we had a bailiff who took an unadmitted exhibit into the jury room, and none of that appeared, would seem to have appeared in the court record. If it had been in a situation like that, I think that yes, I should have gotten a remand hearing. But here, where I realize I've used the word colloquy too much today, but where there wasn't a colloquy regarding the admission, I don't believe that a remand was necessary on these facts. As far as my paragraphs on raising this issue for the first time of appeal, and Mr. Gillette calls it a fatally veiled threat to Rule of 1507. I probably first researched those paragraphs and drafted them in May or so of 2015, so about 2.5 years ago. I did not find much guidance from you or from the Court of Appeals just under what circumstances to consider an issue on first time on appeal within that Supreme Court rule. And those 2 cases are at least the only 2 where I found that there was some sort of a comment about what kinds of issues you might be willing to consider. I probably need to update my research, But that's why I put it in. I think the one with the 1507 reference is because you decided to even consider a speedy trial issue sua sponte in order to avoid a 1507. If there are no further questions, I would ask you to grant Mr. Brown a retrial on these counts.
Counsel, would you have any problem with, after these exhibits were presented and testified about, that without a formal offer to put them in the evidence, the judge just said, I admit them?
I think that it would still require making sure that the defense had no objection. And if it requires asking defense counsel whether she did, and if she says no, then yeah, then that might have been all right too. But that didn't seem to happen here either, unless the court would construe it that way.
Very well. Do we have any more questions? Thank you, counsel.
Thank you.
Thank you both for your arguments this morning. Court will take this matter under advisement.